Hi everybody, welcome to Legal Basics for Complementary Currencies Part 2, the part where we talk about money transmission laws and financial services laws. So I'm Janelle Orsi from the Sustainable Economies Law Center. Normally lawyers teach workshops when they know a lot about something and when they know exactly what they're talking about. With money transmission laws and various financial services laws, these are very complicated areas of law that I've been trying to understand for a while. And I'm ultimately concluding that there are a lot of things that we just can't understand about these laws as they apply to community currencies, complementary currencies, because these laws are really designed to apply to dollars and more conventional financial transactions. So this is my disclaimer. I am doing this webinar in part to give people a little bit of a window into my brain so you can see some of my thought processes on how I'm trying to grasp these laws and how they apply to community currencies. I think it's important for us to understand these laws. There are really severe consequences of not understanding them and not complying with them because of all of the laws we've been talking about in this webinar series. These are the ones that could really get you into prison because some of them, if you violate them, are felonies. So I'm hoping that this will help enlighten people or give you some window into what these laws are about, in what ways they might apply to your community currency organization. And also I'll be sharing some thoughts about how we might want to change these laws, because I think we will want to change them. A lot of these are very helpful laws, but in some cases they're just crazy in how they apply to community currencies, meaning that the hurdles are just far too high. So definitely consult with a lawyer. Don't necessarily rely on anything I've said here, in part because it's also going to become outdated very soon since the laws are changing. And make sure you consult with a lawyer who's licensed to practice in the state that you are operating in. One little thing to let people know up front is I'm not going to talk about cryptocurrencies so much. I haven't had very much experience working with cryptocurrencies, particularly things like the Bitcoin, decentralized cryptocurrencies. And the good news is, if that's what you're wanting to learn about, there is a lot of guidance that's been written recently. You might not like that guidance, but at least there's a lot more clarity in how various money transmission laws apply to currencies like Bitcoin. I don't know if I should say clarity, but there's more information out there. So I'm not going to talk about that, but here's the really fun list of laws that I am going to talk about. I'm not going to talk so much about specific state laws, because I'm going to talk about these laws, most of which are federal. Many of them might have state equivalents, laws protecting consumers and financial services, protecting privacy. Each state might have equivalent laws, but I won't be talking about them. It's important for you to look into them. Let's see. I'm also not going to talk about the regulations that apply when you're engaging in transactions across international borders. I'm just going to talk about transactions within the United States just to keep things a little simpler. So generally this long list of laws, it shouldn't be as intimidating as it looks, although there are one or two laws in there that'll really get you. But in general, these are laws that apply to financial services businesses, providers of consumer financial products, financial institutions. There's a wide variety of phrases that describe the types of activities and organizations that these laws apply to. And a lot of the definitions of things like financial institution are broad enough that they could very well encompass what a lot of community currencies are doing. So, some acknowledgments. A lot of what I've learned about these laws I've learned from Jenny Casson, who's the co-founder of the Sustainable Economies Law Center and CEO of Cutting Edge Capital. She and her intern have done a lot of great research this past summer, her intern Nicole Schneidman, so I'm really grateful to them. We also had a good phone conversation with a lawyer named Carol Van Cleef, who gave us a lot of information because she has a ton of experience in this stuff, so you can look her up as a potential expert in these things. And my coworkers, Chris Tittle and Yassi Eskandari, have also been researching these laws and have been very helpful. So just to have at least one or two cartoons in this presentation, because it's otherwise pretty text-heavy, I wanted to say that a lot of these laws are really designed for a very monoculture type of monetary system, and specifically dollars. And dollars of course, are designed very well for certain types of things in our economy, and they flow quite fast toward things like cheap food, cheap clothes, roof over our heads. This picture, by the way, is of a river that's been diverted into a culvert. And dollars generally don't flow in a lot of the places that we want them to flow toward things that we really value, like small local businesses, elder care, education, renewable energy. Dollars flow toward them, but not as readily. And that's why we want to create a more diverse monetary ecosystem. We want resources to flow in a wide variety of directions and to nourish a much more diverse economy and to support the things that we really value or that make life good. And that's why we're creating a lot of new currencies, a lot of special purpose currencies, local currencies, social purpose currencies, and it's really wonderful and fascinating and beautiful. And we're probably going to have a lot of fun creating the regulations that will apply to these currencies, because it's going to be hard to say that they should be completely exempt from regulation. But truthfully, the regulations that exist now are pretty poorly fitting for a lot of what we want to do. One thing that'll help in creating more nuanced regulations is to create a typology of currencies. And I know there are a few groups around the world who have started to do this. And I just put this up here to encourage anybody who wants to kind of work on this, to kind of get you started or encourage you to work on it, because as we're creating new laws, we need to define, well, what type of activity does this law apply to? What type of currency does it apply to? And there are substantial differences in how currencies operate. So if we can create a typology, that's great. We might also have a typology based on the purpose of the currency. If it's a social purpose, environmental purpose, charitable purpose currency, as opposed to a commercial purpose currency, that should probably make a difference in how it's regulated. So that's a to-do you could add to your list if you're fascinated by these things, is to create a typology. So throughout this presentation, I'm going to use two imaginary currency organizations as an example that I'll refer back to. I'm calling one of them Emus, e-mutual credits or electronic mutual credits, which I thought was pretty clever. And hopefully somebody in Australia will create an emu currency. I think that would be adorable. Anyway, so the Emu Network is a nonprofit membership organization that operates a system through which members can provide services and goods to one another in exchange for emus. So the emus are the credits or the bucks, basically the currency through which people are exchanging with one another in this system. But basically it's in many senses of the word, it's just a barter network, a mutual credit system. And it's designed to remedy dollar scarcity, to diversify the things that we exchange, depending on where it's based. If it's based in a specific region, it's designed to keep wealth local. Okay, so that's emus, and it's an electronic system through which people give one another these emus, so it's entirely online based. The second one will be a print currency called duck bills. So you can just picture in your mind a beautiful bill with ducks on it. And so the vision is, with this imaginary organization, that they are printing duck bills and then they're selling them in their community, their local community, for 90 cents. So one duck bill is sold for 90 cents. And then Duck Bills Inc. has agreed with some businesses in the community to then buy them back at 95 cents per duck bill. So that encourages people to continue to circulate the duck bills in the community, but also means that if certain businesses accumulate too many duck bills and they can't find a way to spend them all, that they can turn them back in for dollars. And also, because this is a social purpose, environmental purpose currency, a second way that they're putting duck bills into circulation is not by selling them, but by gifting them to volunteers who are doing wetland restoration. I had to include that so I could justify calling some sort of currency duck bills. Anyways, so back to all of these regulations we're going to talk about. The purposes of the regulations are really important. Preventing and detecting crime, preventing unfair financial schemes, preventing loss, ensuring redress for problems. And you can almost imagine that anything that you do, any kind of currency you create, if it's going to involve some risk, there's probably a regulation that is designed to regulate it, whether it's securities laws or financial services laws. There's probably something, because when you're putting people and their resources at risk, basically I think society has decided we don't want to let people take too many risks. So think about what you're doing, and is it creating a lot of risk? And if it is, there's probably some regulation that's going to apply, although not 100% necessarily. The question is, which regulation? And that's a question that we'll try to grapple with here. The moral to the story in a lot of this is that the laws do make sense if you regard money as a thing, but money is not always necessarily a thing. Sometimes there are things that represent it, but money, in many cases, is it's an agreement between people, and it's an agreement within a community to accept a certain thing as a medium of exchange. So in the example of emus, emus don't ever exist in a physical form. They really just exist as numbers in an accounting system. And what they really represent is an agreement among individuals and businesses within a network to provide for one another and to track these exchanges with emus and to reward them with emus. So I say this because a lot of the laws apply when you are transferring money from one person to another, and it's almost like you can imagine there's a thing in space. It exists in space, and it goes from one person to another, and somehow in the middle there's a potential that it could be lost or stolen, and that's the awkward thing, is that in many cases there's not a thing that is out there necessarily to be lost or stolen, but there is information that can be confused or misinterpreted, or there are errors that can take place. So it doesn't mean that the laws shouldn't apply. It's just that sometimes when you try to use definitions to figure out how they apply, it just doesn't fit. But and another moral to this story is sometimes it's just going to be hard to figure out how the laws apply, so we might as well just change them rather than try to hone our arguments to death. So if you're creating a community currency, no matter what type it is, and no matter what regulations apply, you should probably just go ahead and make a list of all of the bad stuff that could happen to participants in the currency, meaning the users of the currency, and also a list of all the bad stuff that could happen to the community or to the public at large, because that's really what these laws are designed to prevent. So, breach of privacy, a situation where the entire currency closes down, or the electronic accounting system closes down. Just make a list of all this stuff. And it's kind of a bummer to make this list, because in some cases you're creating a very small community-based currency that's largely or that's partially driven by generosity and trust. And this little exercise is not going to let you assume the best in everyone. It's going to force you to, for at least experimental purposes, assume the worst. But these are all the bad things that the laws are designed to prevent, and regardless of whether the laws apply, you probably should be adopting safeguards to prevent these things. So I'm going to start with the first law that I'll talk about, is the Bank Secrecy Act. The purpose of the Bank Secrecy Act, or the BSA, is to prevent money from being laundered through money transmission businesses, or to prevent people from concealing the receipt of money that they've received in connection with crimes. And if you are a money services business, an MSB, you will need to register with the Financial Crimes Enforcement Network, also known as FinCEN. You'll need to keep information about the transactions that take place. You'll need to report certain transactions, especially if they're suspicious. You'll need to file a suspicious activity report and implement certain procedures to prevent money laundering. So really, the primary purpose is to detect crime and to prevent crime, and to do this through providing a lot of information, tracking a lot of information. So the good thing about this is it's free to register as a money services business through or under the Bank Secrecy Act. And the hard thing is it's just a gigantic administrative hassle. So of course most community currencies are going to want to avoid this. And it might also undermine some of their commitments with regard to privacy or I'm not sure what, but in general I think most currencies are not motivated to comply with this. But it's also important to note that the primary purpose is not necessarily to protect individual consumers. It's to prevent crime, which is probably not something that's on the minds of many of the particularly small-scale social purpose currencies. But anyway, so money laundering, one helpful thing is to just think about the design of your currency and your organization, and to also, whether or not the BSA applies to you, adopt some practices, safeguards against money laundering. So making it more difficult for people to deposit funds or purchase the currency or transfer funds through your platform in ways that might obscure the commission of a crime, for example. So currency organizations where people are not anonymous, where you're trading within a limited network or trading with a limited amount of funds. All of these, I think, are going to make it much less likely that people will launder money or use the money in connection with the commission of a crime. So these are things you might want to implement regardless of whether you register with the Bank Secrecy or with the FinCEN under the Bank Secrecy Act. So who needs to register? This is a little bit unclear. If you're a money transmitter, and here's the definition, I've pasted it in here. So, and this is a video, so I know you can pause the video and just absorb all of these very wordy definitions, but there's the definition of a money transmitter. It applies to a handful of other financial services, institutions, and businesses. One of them is a seller of prepaid access, and that's actually something I want to go back and look a little more closely at, which is to try to determine could a community currency or the organization that is selling currencies, for example, putting them into circulation, could that ever be considered to be prepaid access? But anyways, definition of money transmitter, it looks like it was crafted to be quite broad because at the end you'll see things like informal value transfer system, electronic funds transfer network. It sounds quite broad, almost like the example of Emus. Emus could potentially be covered there. And the FinCEN has come out with some guidance that has specifically said that administrators and exchangers of virtual currency are covered. That, of course, leads us to question, well, what is a virtual currency? And also, what is an administrator or an exchanger? So a few questions will come up in connection with that. So in the guidance that was issued in March of 2013, FinCEN did a few things. They defined real currency as the coin or paper money of the United States. They defined virtual currency as a digital representation of value, which is pretty broad. But they also said that the currency, in order to be covered under BSA, is one which is convertible. So that's something that has caught the attention of a lot of people and gotten us to ask, well, are emus, for example, convertible? And they define convertible as meaning that it has an equivalent value in real currency or acts as a substitute for real currency. So I put a few questions here at the bottom that I would say are still unanswered, or they are things that we could use to make arguments that certain types of currencies aren't covered under the law. But I mean, honestly, everything has a value in real currency if somebody's willing to pay real currency for it. So even emus, even if they're not designed to be exchanged for dollars at any point, could be sold for dollars. So in that sense, it may have a value in real currency. Is it a substitute for real currency? Well, it kind of depends, because the word substitute assumes that there's a normal means of exchange for which you are substituting it. And it's kind of like saying that buckwheat is a substitute for wheat, but that just means that it's sort of emphasizing the primacy of wheat when really buckwheat and wheat are just two different grains, independent of one another, and emus and dollars are just two different currencies that are independent of one another. So it's hard to say that one is meant to substitute for the other. Some other questions that all of these definitions bring up, which I think could be fleshed out a little bit more, and it would help if FinCEN issues some more guidance on these things, but what does it mean to accept a currency or transmit a currency? If you are the Emu Network and all you're really doing is providing an electronic platform where people can account for the emus that they've spent or received, are you actually transmitting anything? There's nothing that's physically moving from one person to another. There's just a change in the accounting. One other question is, what does it mean to be engaged in the business of selling or issuing virtual currency? That engaged, or actually it's engaged as a business. Makes you wonder if you're a nonprofit, and really you're doing this not as a business really, but to serve a social purpose. Does that meet the definition under the Bank Secrecy Act? So these are a few things we might hang our hat on if we're really trying to argue, for example, that emus should not be covered under the Bank Secrecy Act. But okay, let's imagine you're a community currency organization. The Bank Secrecy thing, the Bank Secrecy Act potentially applies to you. Here are some of your options. You could go ahead and register and just deal with whatever administrative hassle comes with being a registered money service business. And, you know, one good thing about doing this is if you do it and you're one of the first community currency organizations that just bites the bullet or takes the leap and does it, you can tell other groups how to do it, which could, you know, maybe in the end it will turn out to be not a huge deal or a huge hassle, but somebody should do it and find out. But another thing you can do, and in fact you might as well do this before registering, is just request an opinion from FinCEN. Basically ask them if you are exempt or if it applies to you, because they might find a way to come back and say, oh, actually this is not what the law was intended to apply to. So you can write them a letter. Just draft a letter saying what it is you're doing, why you think you're exempt, and then ask them to write back and say if you are. If you don't want to call so much attention to your organization, you can also just advocate or ask FinCEN to write more guidance. And they probably are going to be writing more guidance, but ask them to address some specific questions you have, for example, about how the BSA applies to barter networks and mutual credit systems, for example. And if you're really not going to do any of the above three things, just to have a very good argument for why it doesn't apply to you. Make sure you read the law carefully and find some really persuasive interpretations and information that tell you that you're pretty safe in not registering. A couple nice things about the Bank Secrecy Act is that there are a few exemptions. Under the California money transmission law, I cannot say the same thing. It seems to capture everybody, but at least the Bank Secrecy Act exempts entities or persons who are accepting funds and transmitting funds in connection with the sale of goods and services. So if you operate a website through which people are selling homemade products and you are receiving and transferring the money for the sale of those products, at least if I'm reading this right and interpreting it right, you're not a money services business under the BSA. So that's good. Under California law, I think you might be considered a money transmitter in that situation. So, and that's blown the minds of many virtual businesses or online marketplaces. And if you're a natural person who's just doing some of this on an infrequent basis and not for gain or profit, then that's okay. You don't need to register. So that's the Bank Secrecy Act in a nutshell, I guess. But on to the state money transmission laws, because these are giving people a lot of headaches. We heard from the attorney, Carol Van Cleef, that it can sometimes take 2 years in some states to get a money transmission license. So even if you do want to comply with the laws, it's not going to be really easy, and it's going to take a while potentially. My hope is that these laws will change, and that they will change soon and change with an eye toward encouraging like local community currencies and social purpose currencies, because honestly, at least in a few states, California being one of them, this law is crazy. You just can't even comply with it, and I'll show you. Well, here's a little cartoon where the person in the middle is taking $1 from one person, transferring it to another, and helping that other person sell their bread. And that person, if they do not register as a money transmitter under the California MTA, is committing a felony. So if they do want to comply with the law, all they need is a $5,000 initial fee, $2,500 annual fee, a $250,000 bond, and $250,000 net worth to secure any loss that could take place through the transactions. They need to do a lot of record keeping, and they need to fill out a pretty substantial registration application. It requires providing a lot of information. And I should have mentioned that I think the primary purpose of the California MTA is consumer protection. I think part of it is to prevent crimes, but it's like the Bank Secrecy Act, but has this additional consumer protection element. And that's why you need to have the bond and the net worth. It's to secure people's transactions in case there's a loss or fraud or something. So the idea of it is good. But if you're just a small community currency and all you have is about 200 people exchanging with each other within a network, it's just impossible to comply with this law. In fact, there are huge companies that can't even comply with this law because the expense is just huge. And so it basically blocks any sort of small-scale financial services businesses from getting started in the first place. And what is scandalous is that American Express, MoneyGram, and Western Union, and 3 other groups lobbied for the Money Transmission Act, not because they want to protect their consumers. If they really want to protect their consumers, they would just do right by their consumers, or their customers. I think they just want to drive out competition. I feel like it's one of the most blatant examples of big industry lobbying for laws intended to drive out competition, because the law has very little nuance. It doesn't allow, it has very few exemptions in it for small-scale activities or small volume transactions. It's just like, if you're a money transmitter, then you have to do this. It doesn't matter how large or what the risk is. So that's why I say the law is crazy. So here's who it applies to: money transmitters or money transmission businesses, and there's at least 3 things that are defined as money transmission. Selling or issuing payment instruments, so like issuing checks that then can be redeemed for money, for example. Selling or issuing stored value, things like gift cards and so on. And I think this particular definition, stored value, refers to electronic digital records of stored value. And then receiving money for transmission, which is a pretty good catch-all, because one staff person from the oversight agency said that if you take value or funds from one person and agree to transfer it to another person, then you are a money transmitter. So you can imagine this happens all the time, and it covers so many different activities. So that's who's covered. There's a few questions that these definitions bring up. So on the middle one, stored value, so talking about gift cards and those types of systems, if it's a closed loop system, then it may be exempt. So the law says that the definition of stored value excludes any stored value that is only redeemable by the issuer for goods and services provided by the issuer or its affiliate. So let's say you start a restaurant, and then you issue some gift certificates or some sort of certificate or currency that's designed to be spent at your restaurant. That's pretty closed loop. If you in a group of organizations form some sort of alliance or organization, maybe you could say that you are affiliates. So this word affiliate, I'm a little bit curious about it. What does it take to be an affiliate? Because in the example of Emus, we have a group of members. Let's say there's 300 members. They are businesses and individuals who are providing goods and services through the platform. you could potentially say they are affiliates of one another, and therefore when emus are put into circulation and traded, and when the Emu Network is facilitating all of this, it's just facilitating the redemption of stored value for goods and services among a group of affiliates. And it might actually make a difference. The legal structure of the Emu Network, because if each member is, in a sense of the word, an owner of the Emu Network, you could potentially have a stronger argument that they are affiliates. So if it's a cooperative or maybe a nonprofit mutual benefit corporation, you might be able to say that it is a closed-loop system. At the very least, you know that it's a closed group of people and businesses who are exchanging within it. So there's something about emus that, at least in my opinion, should be set apart from normal money transmission businesses. You know, whether or not the Money Transmission Act applies to print currencies, for a while I thought no, because a lot of organizations just put they put the bills into circulation and then don't really facilitate the exchange. They don't really take much part in transmitting the bills after that. But in the example of duck bills, the Duck Bills Incorporated, the nonprofit organization, in my example, has made a promise to accept the duck bills and redeem them for U.S. dollars, or they've made that agreement with some of the businesses in the community that are accepting duck bills. And it makes me wonder, okay, does that mean that duck bills meet this definition of payment instrument? Because looking back at the definition of money transmission, if you are selling or issuing payment instruments, so if you issue a duck bill, but then you're offering to later redeem it for dollars, unfortunately, well, I don't know, I'm a little scared that it could meet the definition of a check or something under the payment instrument definition. So I might advise an organization to not promise to accept dollars back for their duck bills. I'm not 100% sure that this would be a problem or that it would meet the definition of payment instrument, but I'm just worried that it might. So keep that in mind. It's something that maybe we should clarify in the law. And speaking of clarifying the law, so California is now in its kind of its second round of proposed rules for the California Money Transmission Act. We have, I think, roughly until the end of August. I'm not sure the exact date. Maybe a little bit after. We have that much time to give input on their new proposed regulations. The new proposed regulations, fortunately, at least make an exemption for 501c3 nonprofits. And when we gave input on their first round, we had made that recommendation, although we had actually made a lot more recommendations that didn't get included. But I think we're going to give a second round and really urge a lot of people to weigh in and ask that other exemptions be carved out of the law, because especially entities doing a small volume of transactions, either small transactions or a small aggregate, I think that they should be exempted, or at least have fewer hurdles, or at least have smaller fees or smaller bond or asset requirements. If an entity is structured as a cooperative or mutual benefit nonprofit, then that should also be the potential basis of an exemption, because they're democratic entities and they are presumably the consumers have much more power to protect themselves and there's more transparency. So yeah, those are three examples of exemptions that we've argued for. Other ones are for barter exchanges, although the Department of Business Oversight in California recently sent a letter saying that barter exchanges are exempt. We also said geographically limited entities or currencies should be limited. And in fact, most of our input, it wasn't just about currencies and barter networks. It's about really any business that's facilitating transactions or brokering transactions, because we feel like this is a really important platform on which to build a new economy, is to create hubs or cooperatives or organizations that are helping to facilitate exchange. Whether or not it's with dollars, we should allow these businesses to operate. So these are the types of exemptions we should argue for. New York is now in the process of considering new regulations, which I haven't looked closely at, but I think that the deadline is roughly the same to give input, and I think we should argue for similar types of exemptions. Just to give an example of a different state's money transmission law, Massachusetts has a law which rumor has it that they are about to amend. The money transmission, or it applies or it regulates money transmitters that are doing foreign transactions, so not domestic money transmitters. But then it also requires licensing for persons or entities engaged in the business of selling, issuing, or registering checks. And we almost overlooked that, but then I had this question. What is a check? And is it possible that a print currency, for example, could be considered a check, particularly if, like in the example of duck bills, if there's some sort of guarantee to later redeem it back for dollars, or a guarantee that you can go take it to a bank and have it converted into dollars. And so that's brought up some questions. I mean, there's so many different words: money, monetary value, checks, where the legal definitions vary so much across different areas of law. But it's something to be mindful of. Is any law that applies to checks? I wonder, could that apply to a print currency? Overall, if you do have to register in Massachusetts as a check seller, the bond is much lower. It's $100,000, and it's a bond or cash. So, or at least I think it is. So in any case, I think that the hurdles are much lower in Massachusetts. So maybe California can be inspired by that model, and hopefully Massachusetts won't try to make itself be more like California. So the BSA and money transmission laws, these are huge, and these are probably the ones we should be thinking about and worrying about the most. But I'm going to talk about a handful of other areas of law that could apply. One of them is securities laws, and I bring this up because even if none of these other laws apply, if there's some substantial risk involved in what you're doing, you can imagine there's probably some law that will apply, and maybe it's securities laws. As a whole, I think generally currencies aren't considered securities, and we don't probably want them to be, but you can imagine a situation where something you issue is in exchange for dollars, and you're giving, well, let me give a specific example. You're starting a bakery, you create these certificates called bread bucks, and then you sell a whole bunch of them before you even open the bakery, and they are later redeemable for bread. And it's important to note that if the bakery never opens, people are not going to get their bread, and they will have lost their money. So that's why we have laws to protect people in these situations. And there are 17 states that use the risk capital test in determining what a security is. So if you put your money into an enterprise and you have an expectation that you're going to get it back or earn a return on it, and there's a substantial risk that you won't get that, then that might be a security. So at least in California, in the 17 states where this test applies, chances are these bread books are a security, or the offering and the sale of bread books is offering and sale of a security, which means you'd have to register the security, maybe do a direct public offering or qualify it under a crowdfunding law, or you'd need to find some sort of exemption or registration. But in any case, so be mindful of that, of the potential, like learn what a security is, and whether your currency could be considered to be something like a security. Okay, I'm going to breeze through a handful of other laws that we should know about. There's a couple statutes, the Dodd Frank Wall Street Reform and Consumer Protection Act, the Federal Trade Commission Act. Both of them have rules against engaging in unfair, deceptive, abusive acts and practices. These laws don't have any sort of affirmative registration requirement, meaning they're primarily complaint-driven, and meaning you just don't want to engage in these unfair, deceptive, abusive acts and practices. So UDAPs, as they are called. So learn about UDAPs, learn about what they are, and don't do an UDAP. And beware that if you do, there will be a complaint, and then you'll have to answer about that. But even though there aren't affirmative obligations, There are preventative measures that you'll want to consider, like ensuring that participants are well informed of the various risks of what they're getting into, include clear processes for resolving problems. And if you look at what are the definitions of unfair, deceptive, and abusive, it'll give you ideas. Okay, how are you going to prevent injury to consumers? How are you going to prevent misinterpretation or confusion or deception? And a lot of it is by, well, some of it's by providing clear information. It's also by having fair terms for your, like, terms of use and policies so that people don't end up accruing fines or fees or something. So, I guess, yeah, take a look at this list and just make sure you're implementing various safeguards against them. The Electronic Funds Transfer Act. It applies to entities engaging in electronic funds transfer. That does bring up a question of what is EFT, electronic funds transfer, and I think some more research is needed here because, okay, in the case of emus, as I've mentioned, it's not like there's an emu that exists in space and then it goes from one person's account to another person's account. There's really just one centralized accounting system that's keeping track of transactions and giving people emus in the form of basically numbers in an accounting system. Does that qualify as an electronic fund transfer? I don't know. It'd be great if anybody listening to this is inspired to do further research on that, and I've heard that there are a couple cases with definitions of EFT which might help. Honestly, if they are electronic fund transfers, at least as far as I can tell, the affirmative duties that the Emu Network would have to carry out are not terrible. It's not like the Money Transmission Act where there's so many different requirements. They need to provide adequate disclosures and put those disclosures in formats that are readable to their consumers or to the members. They should have processes for resolving errors and unauthorized transfers. This is all really good to do. Provide receipts and other statements, although it's possible this only applies to when you use it at ATMs, so this may or may not apply to emus. And then there's record retention and so on. So the EFT, or Regulation E, that law may not be incredibly burdensome to comply with, but it would be good to understand if it applies to various currency scenarios. And then another fun project for someone could just be to create some best practices for how community currency groups can comply. And we can learn a lot from all the various other financial institutions out there. What policies did they adopt, and what do they disclose, and what are the processes they use to resolve errors, and so on. Another law, the Gramm Leach Bliley Act. This is designed to ensure the security of participants' information, of their personal information and their financial information, and it imposes a lot of affirmative requirements about having a written information security plan, describing it to customers, having a program to protect customer information, identifying risks, regularly monitoring it, selecting service providers that can maintain appropriate safeguards, so perhaps a reputable encryption software program, and then of course evaluate the program, adjust it as necessary. It does say that the plan just needs to be appropriate to the company's size and complexity, the scope of its activities, the sensitivity of the customer information. So honestly, if it's a very transparent network, like time banks tend to be very transparent, and even the transactions that are taking place and the points people are accumulating, it's not as necessary to protect that kind of information because people enter into the community not necessarily wanting to hide that information, but rather to share it for the goal of building community and so on. So that's what I mean by it needs to be appropriate to the size and the scope and the purpose. So So you can go on other websites and go to other financial services businesses and see what kind of safeguards they've adopted, what kind of policies they've put in place. You can learn from that. You don't necessarily have to replicate it exactly as it is. Okay, onward down this list of regulations, we have the Truth in Lending Act, Regulation Z. This applies to entities that extend credit or provide credit to individuals or businesses. So if you regularly offer credit to consumers and it's subject to a finance charge, or it's payable in more than 4 installments, then you'll see the requirements here. But basically, there are going to be some disclosure requirements. You want to implement some procedures for fair and timely resolution of credit, billing disputes, and so you'll have to look more closely at the law. I haven't provided a lot more detail there, but I mean, chances are a lot of groups, it won't apply to you, but in the case of my imaginary Emu Network, it might, because the Emu Network, in my imaginary scenario, extends a credit of 100 emus to each new member. So let's imagine that some members don't want the credit. They just want to wait and provide services in order to earn their first emus. That's fine. But the ones who do get the credit, maybe there's going to be a little charge, a little finance charge for them. Or maybe they're going to have some sort of obligation to pay it back in some form of installments. I'm not totally sure, what it might look like. But let's just say that it somehow is set up in a way that the Truth in Lending Act applies. Might not be the end of the world, because this is small amounts of credits we're talking about, or small amount of credit. But in any case, just want to make people aware of Regulation Z in case it applies. Another law, the Unlawful Internet Gambling Enforcement Act. So if people are using your currency platform to engage in unlawful gambling, then, okay, well actually, whether or not they are, you actually, as a money transmission business, are going to have some affirmative obligations to do some due diligence, just make sure that people aren't engaging in unlawful internet gambling, and potentially block them from doing so. I have to say this law is a little unclear, and I think it would be great if somebody would do a little bit of research on it and maybe create some guidance and best practices for community currency organizations. So what it means to do some due diligence under this law is you should give written notice to all commercial account holders that you cannot use the platform for illegal internet gambling. Now, not all internet gambling is illegal, so first of all, you need to know the difference, and I don't know what the difference is, but in any case, something you'll want to learn about. So give notice that it's not allowed. Do a risk assessment, meaning, look at the person's business. If their business is called Blackjack Gambling Superstore or something like that, maybe you want to do a little bit more investigation just to make sure it's not some sort of illegal gambling platform. This is just me imagining how to comply with this law, because honestly, it's a little unclear to me. Well, how would you detect illegal gambling taking place on your platform? And well, yeah, that's basically it. How would you detect it, or how would you have some sort of signal that you should do a little more due diligence? But it does say if the customer presents more than a minimal risk of engaging in internet gambling, you want to do even more investigation into what they're doing. So if you do find that people are engaging in these restricted transactions, then you need to have a process for reviewing the account, maybe freezing the account, blocking the transactions, maybe reporting the suspicious activity, although it's actually not clear to me that you do have to that you do have to report the suspicious activity. Somebody should look more closely at the law, but, and obviously for many small community currency groups, this is not going to be a common thing. Well, I'm imagining it won't, but in any case, I think this is one of the laws that we just need to learn a bit more about and comply with, although I don't think it'll be incredibly burdensome to comply with it. Fair Credit Reporting Act. I think there are two situations in which the Fair Credit Reporting Act could apply to a community currency organization like Emus, for example. One is if the Emus network decides it wants to report information to consumer credit reporting agencies. And you might at first think, well, why would we do that? But it's actually kind of a good thing because there are a lot of people who don't have access to traditional financial services like credit cards, and so they're not able to build up a credit, or they need to repair their credit. And so, it could be a nice perk of being involved in the Emu network is to build up your credit again. So if you do choose to report information to consumer credit reporting agencies, you need to ensure that it's accurate information. If there's disputed reports, then you need to be willing to investigate that. And also, if you're going to send adverse information to the agencies, you need to inform consumers that you're going to do that. So this is just all to protect them from ending up with a bad credit history or credit score on the basis of information you've provided. So the other situation in which the Fair Credit Reporting Act comes up is if you are using people's credit reports to make a decision about whether or not they can participate or how they can participate. And if you do that, then if you're going to make some sort of adverse decision, like maybe deciding the person can't participate at all, or maybe you're deciding you're not going to extend them the 100 Emu credit, then I think that your obligation would be to inform the customer of that adverse decision, also let them know which credit reporting agency that information came from. So that allows them to take some steps to repair their credit or address the issue. Okay, one last law to talk about is abandoned property laws, or escheatment laws. And every state has some sort of abandoned property law that basically says that if you are some sort of business that's holding property for somebody, like a bank or a wide variety of businesses that hold property, you need to report when that personal property has been abandoned. And you also need to make an effort to find the owner of that property. And if you can't, within a specific period of time, if you can't find them and it's been abandoned for that period of time, you need to transfer that property to the state. And then the state basically treats it as its own property. It might sell it. And then later on, if the owner of that property comes to the state and says, oh, that was mine, well, then the state will pay out the dollar equivalent to them. So this is very interesting, especially when you think about applying it to emus, because emus, of course, as we've said, they are really only usable within a network, within the Emu Network. And so unless the state of California wants to start, well, in the case of California, if they end up with emus, if emus escheat to the state, I guess unless the state wants to participate in that network, or unless the state can find somebody who wants to buy the emus, it's not going to be very useful to the state. So, it's also a little bit of a question of whether emus are property that would even be transferred to the state. So to find out about your state's abandoned property laws, well, in California, it's in the Code of Civil Procedure. There's also a Uniform Unclaimed Property Act, which has attempted to kind of create and suggest uniform laws for all states. You can notice under the Uniform Act that the definition of property is pretty broad, and in fact, it includes unused tickets, presumably tickets that are still relevant, so not necessarily plane tickets or concert tickets, but I don't know, maybe some sort of ticket to a museum that could be redeemed any time. I'm not sure, but I underlined that because unused ticket is potentially analogous to emus. It's kind of sort of a little ticket or a point or a credit that you can hold on to and eventually go and redeem for something. So because I did sort of want to try to find an argument that emus are not property, that they are more like agreements or contracts, and therefore are not of the nature of the types of property you would transfer to the state. But I don't know if we'd be successful in arguing that. So if you are the Emu Network or a similar organization, one question I have that I haven't really totally answered is, could you do something like adopt a policy that says that the abandoned emus will be either held indefinitely, sort of preempting the Escheatment law in a way, or maybe you want to adopt a policy that says that the credit will disappear after a period of time, so may basically be reabsorbed into the system. So I kind of worry that the spirit of the law does not support that, because there are laws, for example, gift certificate laws, that prevent gift certificates from expiring or from losing value. And so like, the idea is that if you're going to extend a certain property to somebody or a certain right to them, you don't want to let it just disappear after a while. That could be kind of abusive. So that might not be the best tactic to avoid having to deal with this escheatment laws. But I do think maybe if each person who joins the Emu Network, if they were to indicate that if they were ever to become inactive or to abandon their emus, that the emus could be donated to a charity, and they could even designate the specific charity. I almost wonder if that's a reasonable way to avoid escheatment. You could also come up with a plan to convert the emus into some sort of physical certificate that you can hand somebody. So literally hand them a certificate that says this is redeemable for 3,000 emus or whatever the person had in their account. You can send it to the state. You can send them that certificate. So then it is something valuable the state has or holds on to. Or you can send it to the person, because, just because the account has been inactive doesn't mean you can't contact the person. I mean, in this day and age, it's a little hard to lose track of people because of their online identities. So it could just be that the person's lost interest in using the emus, or they haven't found a good use for them within the network, or maybe they've moved out of the area. But if they have some sort of certificate that says, well, this can later be used to open an account and credit 3,000 emus, then they have that, or they can sell it, they can give it away, they can donate it. So that might be a solution. But if you truly can't contact the person, you've truly lost touch with them, you can't find any beneficiaries, then maybe you want to send that thing to the state, the Emu certificate, I guess. A question that I haven't answered, although I hope the answer is no, is there any sort of requirement that would say that the emus have to be converted to dollars before they're sent to the state? But I don't think so. I think you can transfer all kinds of property to the state, and then it's the state's job to sell it or convert it to dollars as needed. I certainly hope so, because obviously emus are created to remedy dollar scarcity. It would be a pain to turn them into dollars and send them to the state. Okay, so a few takeaways from this whole webinar on all these financial regulations is that, of course, a lot of these laws are really helpful because they protect us, and they protect the users of the currency, and they prompt the currency organizations to adopt safeguards. But in many cases, they are not helpful because just the scale and the scope of compliance required is far disproportionate to what people are actually doing in consideration of the size and scope and purpose of what they're doing. So we need better tailored laws. We can, of course, continue to dig deeply into how these laws are interpreted and to really hone our legal arguments and to really try to argue, well, these laws don't apply to what we're doing. But honestly, I think it's better to just create more nuanced laws that consider the wide range of currencies that we are creating in our economy. So some policy strategies are to create exemptions, carve out exemptions for specific type of activities. It could be an exemption from the entire law, or it could be an exemption from certain requirements of the law, so certain burdens imposed on the organization. And so this could be a good advocacy strategy, is to just, you can create a typology of currencies, you can create all kinds of descriptions of currencies based on the size of the transactions, the total volume, whether it's geographically limited, how it's legally structured, whether it has a social purpose, and then you can define these clearly enough that you can then create exemptions in the law for them. And that is basically our strategy and the input we've been giving to the Department of Business Oversight in California, is to say, here are a few examples where you can create exemptions. Either completely exempt it from the Money Transmission Act, or exempt it from the requirement to keep such a huge bond, or to keep certain assets, or to pay a $5,000 registration fee, for heaven's sake, that kind of thing. Other policy strategies, and I'm not really sure what I think about all of these things, but we could create a uniform model law and just encourage every state to adopt it. So that definitely makes it a lot easier if you're operating across state lines and you know what you're going to deal with in the next state. Maybe create a federal law that completely preempts all of these state laws, especially the state money transmission laws, because it really does inhibit a lot of creative and innovative economic activity when you have to find out what each state's payment laws and financial services laws are and then comply with them. I mean, you really have to be a very large, wealthy company to afford to do that. And so if there are a federal law that says, this is how you register, this is what you're going to do, and as long as you do all these things, you don't have to register under any state money transmission laws, for example. It's kind of similar to certain securities laws that preempt state laws. So the new crowdfunding law is going to preempt state securities regulations if you comply with the requirements of the new Crowdfund Act. So similarly, perhaps we can create such a federal law. Whether that's a good idea strategically, I don't know, because also in theory we want to give states the right to set the terms of their own financial rules and regulations. So it's not necessarily a very nice thing to do to take that away from states. Kind of conversely, maybe you can create some sort of intrastate exemption under the Bank Secrecy Act to basically say you don't need to worry about the Bank Secrecy Act as long as you're only operating within your state and as long as you're complying with your own state's money transmission laws. So if you're going to jump through all the hoops to comply with the Money Transmission Act in California, maybe the federal regulators can lay off and just trust that you're in good hands in California. So these are three kind of similar concepts but very different strategies we can employ to make the laws a little more simple. A couple other ideas that we've tossed around is to create some sort of insurance program for community currencies that's designed to compensate people in the event that there is some sort of loss through the use of the currency system, kind of like how the FDIC insures deposits for banks. So that would create a lot more security rather than having money transmission laws that require us to keep a bond or to maintain certain assets. We can just register or pay to be part of some sort of insurance system that protects a wide range of currencies. We could also maybe create some sort of oversight organization, some sort of private, nonprofit regulatory body, or some sort of trade organization that provides best practices and oversight and maybe some sort of certification, and then go to state lawmakers and say, hey, look at this organization we created. It's helping keep all these groups really accountable and well organized. Maybe you could empower this group to be some sort of certifying agency that's an alternative to registering under the state or federal processes. I think there's some similar agencies for like check certifying, or check services businesses, because I think under the Massachusetts money transmission law, there's an indication that the state might participate in some sort of multi-state licensing system. This last slide here is just a list of some interesting legal research projects that people can do. I won't list them off here, but in general, Sustainable Economies Law Center is trying to maintain a clearinghouse of information about these legal issues, but there's a lot of information, especially on a state-by-state basis, and so at communitycurrencieslaw.org, maybe ideally we would have 50 different pages for 50 different states, especially to look at the money transmission laws. So if there are volunteers out there who really want to dig in depth into your state laws and then summarize them for communitycurrencieslaw.org, that would be great. And yes, as I've mentioned throughout, there's a lot of room for more research, so hopefully some folks out there are inspired to do that. And then one final thought is that the Sustainable Economies Law Center got some early funding to do research and education around community currencies and the law, and we created this website but we actually haven't gotten any funding to continue this work. So, and this is actually a time where this work is really needed. And so if you're out there and you want to contribute to our work, you can go to our website, theselk.org, and click on contribute or donate. And if you are a funder or you have connections to funders, I think our goal really is to have a dedicated staff person who is constantly monitoring these laws, helping us craft model policies, helping us give input in the rulemaking proceedings, helping educate people and create more webinars like this. Honestly, there's so much work to be done, and I think we lend a particular voice to all of this, which is the legal issues specific to small-scale local currencies and social purpose currencies and how they might be particularly crafted for such currencies, and how the legal structures, the democratic structures, cooperative structures of such organizations should actually make a difference in how they're regulated. So that's just a little bit of a pitch for the Sustainable Economies Law Center, and for people to support our work. And that is all I have. Thank you.